lords, my lady, there's a little billet-doux from me on your desks, headed the propositions on reasonable expectation of privacy. In view of your lordship's desire to move things more quickly, I felt that if I were to cut and paste that part of my speaking note, which is what it is, so there'll be certain shorthands and the like, but I thought I might be able to speed through that.
That's very good. Thank you.
And it also means that Melena Friend will have a chance to see what he may have missed.
These are your 9 points.
These are exactly. So they're the 3 propositions of law, and then the 9 factors. What I hadn't developed, I've done effectively the first 2 this morning.
Well, you've done 1. We're about to do 2, and I said, is that a convenient moment to stop?
Yes. What I hadn't developed at all this morning was paragraphs 4 to 5, and I'll just make the point very quickly. The Google Spain litigation, and I understand the NT1 case is due to be in your lordship's court next week, brings into play a number of factors which we submit are also likely to be relevant when you're deciding whether there's a reasonable expectation of privacy in this context. Because the Google Spain type scenario, the context is, has previously public information become private information with the passage of time. What we're concerned here with, of course, is does something else change the dynamic so that the calculus, so that previously public information becomes private information. But there are a number of factors that the court took into account in the Google case, applying some guidelines produced by the so-called Article 29 Working Party. That was the Article 29 of the Data Protection Directive, which is, since the Data Protection Regulation came into force, has been replaced. But these guidelines were applied by Mr. Justice Warby, and I've drawn out a few of them. I've set out the passages where you'll find them, but we submit that these are likely to be relevant factors, one of which, interestingly, is, if you look at paragraph 4.4 of my note, in what context was the information published? Was the content voluntarily made public? Was the content intended to be made public? And could the data subject have reasonably known that the content would be made public? So there's a similar reasonable foreseeability context there. But I won't develop those in any more detail, just to say that submit that those factors are likely to be relevant, but I won't take you to a rather lengthy judgment. You have the key paragraphs that I consider to be relevant in my note. So I can turn to the 9 factors. I've developed the first one, as your lordship has identified, the fact that there is an investigation which brings with it some stigma. The next point is the carrying out of online research, even with publicly available material, to build a profile. And my lords, the key document I'll go to first, in fact, is at paragraph 5.3, the Covert Surveillance and Property Interference Revised Code of Practice. Now, this is the RIPA Code of Practice, which only came into force in August of this year. And the previous version of the Code of Practice was before Mr. Justice Ouseley. But as I'll show you, there's a number of paragraphs in this which are not in the earlier guidance, which are likely to be of some relevance. And if I might then ask you to take it up, it's tab 111 of tab of bundle 5. It begins at page 4540, but the relevant passages begin at page 4554. So I'm going to look at RIPA in a moment, but in a nutshell, one of the questions that the court, one of the questions that has to be looked at is whether the information is likely to be private information, and private information is defined as information touching upon a person's private or family life. So it's exactly the same test under RIPA, whether it's private information as it is under Article 8. Paragraph 3.1, page 4554, sets out the criteria for whether something is directed surveillance, which is, as you'll know, our ground 5. This is what this amounted to. Surveillance is directed surveillance if it's covert but not intrusive, conducted for the purposes of a specific investigation, likely to result in the obtaining of private information about a person, and not conducted by way of an immediate response to events. And then there's a passage, 3.3, private information, 2000 Act states that private information includes any information relating to a person's private or family life. Paragraph 3.4. Whilst a person may have a reduced expectation of privacy when in a public place, covert surveillance of that person's activities in public may still result in the obtaining of private information.
Sorry, we're looking at 3.3.
I wasn't going to take you to 3.3, my lady, but I'm happy to go back to it. But 3.4 was where it's quite a long document, so
No, I understand that, but I mean, in the current context, information which is non-private may include publicly available information.
Yes. Yes, and then it may become private in the circumstances which I hope I'll demonstrate through this document. So paragraph 3.4, whilst a person may have a reduced expectation of privacy when in a public place, etc. And then this is likely to be the case where that person has a reasonable expectation of privacy, even though acting in public, and where a record is being made by a public authority of that person's activities for future consideration or analysis. Surveillance of publicly accessible areas of the internet should be treated in a similar way, recognising that there may be an expectation of privacy over information which is on the internet, particularly where accessing information on social media websites. See paragraphs 310 to 317 for further guidance about the use of the internet, and I'll come to those in just a moment. Paragraph 3.5. Private life considerations are particularly likely to arise if, and we've assuming this is very relevant, if several records are to be analysed together in order to establish, for example, a pattern of behaviour, or if one or more pieces of information, whether or not available in the public domain, are covertly, or in some cases overtly, obtained for the purpose of making a permanent record about a person, or for subsequent data processing to generate further information. In such circumstances, the totality of information gleaned may constitute private information, even if individual records do not. My lords, there may be more that is relevant than the bits I'm going to take you to. You'll forgive me if I skip to paragraph 3.6. Private information may include personal data, such as names, telephone numbers and address details, where such information is acquired by means of covert surveillance of a person having a reasonable expectation of privacy. A directed surveillance authorisation is appropriate. And then, my lords, my lady, if we pick it up at paragraph 3.10, online covert activity. And this is the stuff. This is the bit that's new in the new guidance. The growth of the internet and the extent of the information that's now available presents new opportunities for public authorities to view or gather information which may assist them in preventing or detecting crime or carrying out other statutory functions, as well as in understanding and engaging with the public. It's important that public authorities are able to make full and lawful use of this information for their statutory purposes. Much of it can be accessed without the need for RIPA authorisation. Use of the internet prior to an investigation should not normally engage privacy considerations. But if the study of an individual's online presence becomes persistent, or where material obtained from any check is to be extracted and recorded and may engage privacy considerations, RIPA authorisations may need to be considered. The following guidance is intended to assist public authorities in identifying when such authorisations may be appropriate. The internet may be used for intelligence gathering and or as a surveillance tool, where online monitoring or investigation is conducted covertly for the purposes of a specific investigation or operation, and is likely to result in the obtaining of private information, and authorisation for directed surveillance should be considered. And then picking up at 3.12, in deciding whether online surveillance should be regarded as covert, consideration should be given to the likelihood of the subject knowing that the surveillance is or may be taking place. Use of the internet itself may be considered as adopting a surveillance technique calculated to ensure that the subject is unaware of it, even if no further steps are taken to conceal the activity. Conversely, where a public authority has taken reasonable steps to inform the public or particular individuals that the surveillance is or may be taking place, the activity may be regarded as overt, and a directed surveillance authorisation will not normally be available. 3.13, as set out in paragraph 3.14, depending on the nature of the online platform, there may be a reduced expectation of privacy, where information relating to a person or group of people is made openly available within the public domain. However, in some circumstances, privacy implications still apply. This is because the intention when making such information available was not for it to be used for a covert purpose, such as investigative activity. This is regardless of whether a user of a website or social media platform has sought to protect such information by restricting its access by activating privacy settings. Where information about an individual is placed on a publicly accessible database, for example, the telephone directory of a company's house, which is commonly used and known to be accessible to all, they're unlikely to have any reasonable expectation of privacy over the monitoring by public authorities of that information. Individuals who post information on social media networks and other websites whose purpose is to communicate messages to a wide audience are also less likely to hold a reasonable expectation of privacy in relation to that information. So I accept that is a factor against. Whether a public authority interferes with a person's private life includes a consideration of the nature of the public authority's activity in relation to that information. Simple reconnaissance of such sites is unlikely to interfere with a person's reasonably held expectation of privacy and therefore is not likely to require a directed surveillance authorization. But, and this is very important, my lords, where a public authority is systematically collecting and recording information about a particular person or group, a directed surveillance authorization should be considered. These considerations apply regardless of when the information was shared online. And they give an example. A police officer undertakes a simple internet search on a name to find out whether a subject of interest has an online presence. This is unlikely to need an authorization. However, if having found an individual's social media profile or identity is decided to monitor it or extract information from it for retention in a record because it's relevant to an investigation or operation, authorization should then be considered. And example 2 is also relevant. We pick it up. An initial examination of the online profile is not going to need an authorization, but if during that visit it's intended to extract and record information to establish a profile, including information such as identity, pattern of life, habits, intentions or associations, it may be advisable to have in place an authorization even for that single visit.
I don't really see how that helps us. To say it may be advisable, or you may wish to consider a authorization, it doesn't really help us, does it, answer the point of law here?
Well, my lord, I accept that in the end, what you say is going to count, and what the guidance says, if it's wrong, will be wrong.
I mean, much of this is couched in, you need to think about it.
Yes, I accept that, my lord. But I think what the point that's being made, and the point that I seek to draw from this, is that when you consider my 9 factors, there is a reasonable expectation of privacy in relation to the material, even if you've put it online yourself, and even if you intended for it to be widely shared, and that material will become private depending on what a public authority does with it, and it can become private information very quickly. I mean, my Lord Justice Irwin put to me the question this morning: could a single internet search give rise to a reasonable expectation of privacy? Well, the guidance says it could. If from that single internet search you're extracting information and creating a permanent record, if you are in the process of carrying out an investigation rather than a simple preliminary inquiry. So those are all factors which I've drawn out as being relevant in my 9 factors, and all I seek to demonstrate through this guidance, my lords, is to show that the RIPA guidance accepts that these are all factors that are relevant. It'll be a matter for your lordships and your ladyship to decide whether in fact, in Mr. Butt's case, they did give rise to a reasonable expectation of privacy. But my lords, what I seek to show in little 2, or paragraph 5.2 of my note, is that it's the creating of a profile that is particularly important. A profile that records a person's habits, behaviours, associations, where they go, who they speak to, what they do. And I've shown you the Covert Surveillance Revised Code of Practice. You've got the relevant paragraphs. One paragraph I haven't shown you, but while we're on it, is particularly relevant, although it's more relevant to number 5 on my list, which is paragraph 4.5.7, which is when internet searches are carried out by a third party. So if I could just go back to the guidance, paragraph 3.17 on page 4559. internet searches carried out by a third party on behalf of a public authority or with the use of a search tool may still require a directed surveillance authorization. So, by a third party on behalf of a public authority or with the use of a search tool. And my lords, my lady, if you go to paragraph 4.3.
It's not that it will, it may.
Well, my lords,
My point I'm making.
it may be after your lordship's judgment that it will need to be revised, couched in stronger terms. I would respectfully submit that it would need to. If you go to page 4575 in the same document and look at paragraph 4.32, and this is where the role of student rights becomes relevant to this guidance. In some circumstances, it may be appropriate or necessary for public authority to work with third parties who are not themselves a public authority to assist with an investigation. Where that third party is acting in partnership with or under the direction of a public authority, then they are acting as an agent, and any activities that third party conducts, which meet the 2000 Act definitions of directed or intrusive surveillance, should be considered for authorisation under those acts. Similarly, a surveillance authorisation should also be considered where the public authority is aware that a third party that is not a public authority is independently conducting surveillance, and the public authority intends to make use of any suitable material obtained by that third party. So, my lords, we respectfully submit that supports our proposition that receiving the fruits of the investigations carried out by student rights itself gave rise to a reasonable expectation of privacy. In terms of this issue of profiling, particularly profiling from using powerful internet search tools, the Strasbourg Court and the Court of Justice of the European Union has expressed particular concerns about how that can give rise to vast amounts of information which can cast light on individuals' private lives, even if on the face of it that data is not private, even if in isolation. The first case to show you, if I may, is referred to paragraph 5.2, a case called Szabo, which your lordships will find in volume 4, tab 89.
I think it's
Paragraph
probably
7.
volume 3.
Volume 3.
No, sorry, my fault. I've got the wrong one.
Volume,
Apologise. 89.
it's 89,
Yeah.
so it's volume 4.
Yeah, thank you.
If we start, my lords, at paragraph 66 of the judgment, this was the case where the courts were looking at the ambit of the courts of the Hungarian authorities' powers to conduct secret surveillance. And the court notes that under section 7E3 surveillance, it's possible for virtually any person in Hungary to be subjected to secret surveillance. The legislation does not describe the categories of persons who in practice may have their communications intercepted. In short, the power is exercisable for the purposes of any any investigation involving national security. So you'll find that in the same judgment at paragraph 11. You just go back to page 3407. In paragraphs 11 and 12, you can see the two different powers of secret surveillance. I was going to have to take your lordships to this for the Article 8.2 point anyway, so I will kill two birds with one stone. Two powers that were exercisable in Hungary under 7E2, this is paragraph 11. This scenario is subject to judicial authorisation. But the one under section 7E3 is authorised by the Ministry in charge of Justice, either in order to prevent terrorist acts or in the interest of Hungary's national security, or two, in order to rescue Hungarian citizens from capture abroad. Section 7E3 surveillance takes place under the rules of the National Security Act, under the condition that the necessary intelligence cannot be obtained in any other way. Otherwise, the law does not contain any particular rules on the circumstances in which the measure can be ordered, as opposed to Section 7.2 surveillance, which is conditional on the suspicion of certain serious crimes. The time frame is 90 days, which can be prolonged for another 90 days. However, the latter has no right to know about the results of the ongoing surveillance when called on to decide its prolongation. Once the surveillance is terminated, the law imposes no specific obligation. 11 and 12, sorry, of the same judgment, 3407, page 3406. So that was the power that they were looking at. So if you go back to paragraph 66, my lords, my lady, 73439, picking it up at paragraph 67, it's of serious concern, however, that the notion of persons concerned identified as a range of persons might include indeed any person and be interpreted as paving the way for the unlimited surveillance of a large number of citizens. The Court notes that the absence of any clarification in domestic legislation as to how this notion is to be applied in practice. For the Court, the category is overly broad because there's no requirement of any kind for the authorities to demonstrate the actual or presumed relation between the persons or range of persons concerned and the prevention of any terrorist threat, let alone in a manner enabling analysis by the authoriser, which would go to the question of strict necessity with regard to the aims pursued and the means employed. My lords, the subsequent paragraphs are also important, but I wanted to draw out, particularly on this point, paragraph 70, where the Court said this: the Court would add that the possibility occurring on the side of governments to acquire a detailed profile of the most intimate aspects of citizens' lives may result in particularly invasive interferences with private life. Reference is made in this context to the views expressed by the Court of Justice of the European Union and the European Parliament. Now, my lords, that's a reference to the Digital Rights Ireland case, which is set out at paragraph 23 of the same judgment.
What do you mean by the most intimate aspects of citizens' lives?
Well, my lady, I will take you to digital rights next, and you'll see what is meant. This threat to privacy must be subjected to very close scrutiny, both on the domestic level and under the Convention. The guarantee required by the extant Convention case law on interceptions needs to be enhanced so as to address the issue of such surveillance practices, i.e. those of the kind that were being considered in digital rights, in Tele2 and the Watson case, which obviously happened after this judgment. This threat to privacy must be subjected to very close scrutiny both on the domestic level and under the Convention. The guarantees required by the extant Convention case law on interceptions. Sorry, I've just read that. So it's about profiling, but it's also about our point 3 on this list, which is, it's also about the point 4, the automatic processing of personal data, because both those issues fell to be considered in digital rights. Now, I accept, my lords, my lady, in relation to digital rights and also the Watson case, that the Strasbourg court is dealing, the Luxembourg court was dealing with Articles 7 and 8 of the Charter of Fundamental Rights. But I'm going to take you to the propositions in those cases because, in my respectful submission, they are applicable here, indeed in the same way that the European Court of Human Rights felt they were in the Zamo case. So if I may take you to the digital rights case, which is at volume 5, at tab 108. There's just two paragraphs I'd like to show you. The first one is in paragraph 27. This is the passage that's referred to in Zabo. It can't be read completely out of context because this is in the context of the Luxembourg Court's consideration of the question of whether there was an interference in private life, which begins in paragraph 23 in the judgment that we're looking at the moment. But this was concerned with the directive, the European Union directive, that required providers of publicly available electronic communication services to retain communications data for the purpose of making them accessible to the authorities. And although the data that could be obtained did not include the communications themselves, what the court found, see paragraph 27, is that those data taken as a whole well, in fact, it's probably better to read paragraph 26 as well.
Shall we read those 12 sections?
Thank you, Mike. Well, if you would in fact go on and read paragraphs 28 and 29, please.
All right, but those facts are so remote from our own.
Well, my lords, I accept that what the court was concerned with there was the obtaining of information which was not had not been deliberately put into the public domain. What they were concerned with, however, was information which in and of itself may not have been private. The communications data or would have had very little private information about it. It was the fact that when pulled together with all the other information, it could lead to very detailed understanding of a person's life.
Of a person's private life.
Of a person's private life.
Yeah, the life that is inherently private.
Well, my lord, in the same way, if you pull together a lot of information that somebody has put online, and I don't just mean information that they've published in a blog, or even things that they've put in a tweet, but every time that their name has been mentioned, every Facebook tag that there is that's publicly available on a site that's not had restrictions put on it, every piece of information about that person, particularly if you're using powerful social media monitoring tools like RipJar, then you can obtain a vast amount of information about an individual.
You can, but speaking for myself, I cannot see how that case can help us answer the present one. But the fundamental point and the decision of the judge was that what was collected here was information about where Mr. Butt had given speeches and what his speeches were. That's the content of the information here. So the issue is where somebody wishes to promote certain views in public and they go to institutions in order to do that. Why is that private? I don't see that case.
No, my lord, I answered the point I'd want to draw from these cases is about profiling. Now, the point is that publicly accessible information online that a person has put out themselves or other people have put out that names them can give rise to very detailed knowledge about that person.
Well, if you, that's right, but it is obvious. I mean, if you say the same thing, if you follow any person around in their daily activities which take place in public, for example,
Yes.
using covert surveillance techniques to do it in order to build up a profile of their life, that's without any difficulty at all. Although those activities are taking place in public, that is
Yes.
that engages Article 8,
Yes.
which we're not in that.
Well, my lady, why would it be any different in principle in that case? If a member of the EAU had gone to each of the speeches that Mr. Butt had given, having seen them advertised and had made a record of what had been said. This is in a pre-internet world.
I think it's for you to answer that question.
Well, my lady, I asked the question rhetorically, if I might put it that way. I put the question back to your ladyship, that if you were to take the example your ladyship's given to me of somebody following somebody around in public at their at events at which they are which are in public, which they've chosen to carry out in public.
You see no distinction between somebody popping down to the shops and picking items off the shelf and chatting with their neighbours,
Well, of course,
and
that's
somebody who puts a speech out for public consumption in order to promote their views.
well, my lady. If one goes back, as I said, to the 50s, or in fact not even the 50s, back to the 80s and 90s when the Secret Services were carrying out investigations to find out if somebody was a subversive. And they gathered all sorts of information that a person had chosen to put out.
We're not talking about all sorts of information. That's the whole point. That's what my lord's questions are directed at. This is a case about what your client has said in public and wants to say in public. Not merely has said, but wants to say in the future. And there's been a degree of assembling published information together, not merely public information or public information, but information for the most part deliberately published by your client in a lecture or whatever. And the central part of his case, as I understood it, was that he invokes his Article 10 rights.
Yes. Well, my lord.
Meaning he wants to say these things in public.
Well, my lord,
I'm not quite sure. Just let me put it
Sorry,
again.
my lord.
I'm not quite sure how stigma comes into this case, since what he is saying is that his views are entirely proper, and he wants to go on saying them. There's no focus on his private life in the ordinary sense of that. There's no focus on his intimate life, on his movements, on his associations.
Well, my lord, with the greatest respect, I disagree with those last two propositions, because where he goes to speak and who he shares a platform with and who he has shared a platform with online when he writes for Islam 21st Century were all factors that were taken into account when the EAU formed a judgment that he was an extremist by reference to, for example, his associations.
Well, then why don't you focus on those aspects of the facts of this case that you say stand out? Never mind the... I'm sorry, I just think that this general trawl of principle that arises from wholly different situations.
I think these points are intended to help you because, speaking for myself, I can see there's a point somewhere there. And what I'm concerned about, that's why I've been from time to time saying, do you mean this? Can we summarise this? Is that I'm concerned I'm losing my sight on the critical issue here. And we start off with the position of the judge, which is that, exactly as my lord has formulated it, which is you don't get to engage Article 8 here because we're actually talking about things that are public, he wants to be in public, and so on and so forth. And I think, from speaking for myself, it's entirely a matter for you, you're a very experienced advocate, but you can refer us to all these cases, but if they're so removed, I think it obscures the strength of your case on other points. I certainly take your point that one of the points Mr. mentioned, even if these are public statements, would Mr. About have foreseen that somebody on behalf of the state was going to collect them in order to put him in a category of people who are extremists? So I would contrast that on the one hand with something you haven't dealt with, but occurs to me as you're speaking to my lord. If somebody wanted to carry out an analysis, a state body wanted to carry out an analysis of the views of Mr. Butt, and so they want to go to all the things he said in order to deconstruct and analyse his various statements, in order to understand what his philosophy is. I mean, I would find it very difficult to see that engages Article 8.
Well, my lord, that's precisely what they've done, and the reason why it engages Article 8 is because the process of determining whether somebody is an extremist.
But the example I was giving was outside the EAU. It's all he wants to do. All that somebody wants to do is, let's say, what they're doing is they're going to meet somebody in the Foreign Office is going to meet somebody from the Middle East, and let's say Dr. Butt's name has been mentioned in relation to the person they're going to meet, and so in order to prepare the diplomat properly, they want to analyse exactly what Mr. Butt said, not for the purpose of making him an extremist or putting him in some unit, but just to understand what his philosophies are. It was very difficult to say to me, well, just doing that for that purpose engages Article 8.
Well,
but you disagree with that?
That's not my summation, my lord. No. What I've sought to do is to give you a number of factors which, when you,
yes,
I have put it both collectively or individually, but for present purposes, I only have to establish that collectively they do give rise to a reasonable expectation of privacy in relation to even information that somebody has put online. And it's the fact that his views are sensitive in the sense that they refer to his religious and political views. They are, while publicly expressed, they are being collected together for the purposes of assessing whether he is an extremist.
Yes.
And that
that's submission I understand.
that is the critical. Well, that's the critical point. That was my first factor.
I know, but we're awash with all these cases.
Well, I'm afraid that there are a lot of cases, and the courts are working their way through these issues, because what is the case?
Does that encapsulate? Does that submission, which is very clear, encapsulate the core of your case on this point? That his views reflect and refer to religious and political views being connected together to assess whether he is an extremist. I mean,
Yes.
that is a very simple proposition.
Yes.
Is that the core of your
Yes,
case?
by reference to where he's been, who he's spoken with, who he's spoken to, and what he's said.
That's clear.
And my lords, I don't think I need to say very much more than just to draw out, in this context, that, as I said, receiving those fruits from somebody else is as much an interference with Article 8 if the state has encouraged it in any way. So the fact that the majority of the research was originally done by digital rights is neither here nor there. By student rights. And in any event, once they disclose that information, including the assessment that he was an extremist, to the Prime Minister's office, and they hold that assessment, which they may disclose in future. For example,
Once it's been disclosed to the Prime Minister's office, yes,
and the fact that it can be shared in future. For example, if a prevent coordinator in one region is approached by a university saying, we've got a student union, a student society that wants to invite a Dr. Salman, but do you think it's safe to invite him? It's accepted. And in those circumstances, the EAU will share that information with a prevent coordinator, and the prevent coordinator can then share that with the university to say, well, he's been assessed as an extremist. I mean, that is the reason for why the EAU exists, to find out who is an to form a view about whether someone's an extremist, and then to share that with bodies that need to have that information for the purposes of their Section 26 duty. So, my lords, that, in my respectful submission, is why this case involves a reasonable expectation of privacy.
Are you going to refer to the case relied upon by the judge?
Just remind me which case you mean, my lord.
That case. What is the case?
I'm not sure that I know which one you mean. Do you mean cat?
The W case.
Cat and J. Yes. Cat. He relied on cat.
Yes. Well, I'll tell you.
Well, he didn't rely on it. He distinguished cat.
He distinguished cat. Well,
Are you relying on cat?
In my skeleton argument, which I've adopted for the purposes of my submissions, we've set out in detail why cat is determinative in our favour in this case, and what is different about cat to our case. But there's two key points.
Do you
why
rely on
cat is different? Yes, but the two key points why cat is different, and why in cat the Supreme Court held that there was not a breach of Article 8. They accepted that his Article 8 rights were engaged.
Yes, well, that's what we're doing.
But the question was whether there had been a breach, and the key point is they found he was entitled and able to exercise his rights under the Data Protection Act. Now,
Yes,
that's an Article 8.2 issue, so I was going to come to it in that context.
I see. Well, but I mean, are you saying in relation to Article 8.1,
Yes.
the engagement point?
Yes.
I mean, there were some general statements that were made by Lord Subsection with whom a number of people agreed, the majority agreed. laying down when the collection of data about an individual
I'll tell
would
you
engage
to-
Article 8, but you, I mean, that, you haven't referred us to that yet.
It's the next case, my lord,
Oh,
on my list. It's tab 2. Sorry, it's volume 2.
But I think the critical issue here is going to be whether or not the judge was right to distinguish the case, or whether it was binding on him and on us.
Yes. My lord, if you could turn up tab 36 of volume 2, page 1139. 1139. Page 1139. In fact, you start
Which
tab
tab was it?
36 of volume 2.
Tab 36.
Of volume 2, yes.
For cat, it's 32.
32, I'm very sorry. No, I don't know
That's
if I've
not-
seen it down incorrectly.
Cat is 32.
But the key passages for whether Article 8 is engaged are at start at page 1138, and it's paragraph 3 through to 6. And my lords, I don't need to dwell on paragraph 3 or 4. Paragraph 4 refers to the requirement of a reasonable expectation in the relevant respect. That's the 4th line of paragraph 4. And then the last few lines. In this context, mere observation cannot, save perhaps in extreme circumstances, engage Article 8, but the systematic retention of information may do.
Which paragraph? Paragraph 4?
Paragraph 4, yes. Last 4 lines, last 3 lines of
Oh,
paragraph 4.
yes, I see. Exactly.
And then
It's really paragraph 6 is the good.
Well, paragraph 5 he refers to case law, including the proposition that I took you to earlier, that the making of a systematic or permanent record is sufficient to engage, or may be sufficient to engage Article 8. That's the reference to PG in the United Kingdom, paragraph 57, at the top of the page on 1139. And then he refers to BB and France.
Yes.
The 3rd line, the mere storing via public authority of data relating to the private life of an individual engaged Article 8. And S, the United Kingdom held that Article 8 was engaged by mere storage. And then he refers to Lord Hope in L, how even public information such as a criminal conviction may become part of a person's private life once it recedes into the past and other people are likely to have forgotten about it. So the same principle, the Google Spain point, in the EU context. And then these cases and others like them all have particular features which differentiate them both from each other and from the present cases. But it's clear that the state's systematic collection and storage in retrievable form, even of public information about an individual, is an interference with private life. Now, my lords, what we say about the judge's conclusion on this is that, firstly, he did not take into account the fact that the information that they received from student rights was relevant to the question of private life. In fairness, I don't think I developed it below, but the covert guidance, RIPA guidance, makes that very clear. So a public authority that has obtained that information is fixed, if you like, with the responsibility that brings with it. And in relation to his conclusion about Mr. Catt, the key point in relation to Catt, as I said, was the Article 8.2 point, which I'm going to be coming to when I come to Article 8.2. Sorry, I'm just going to fill up my glass.
Is there anything more to be said on 8.1? I mean, you've given us the 2 broad propositions. You've given us your nine different categories. You've referred us now to what's said in Catt. You say Catt's binding on us, and we fall within it. I mean, is there any more that you need to say or want to say? You've dealt with the question of importance of profiling.
So what the point that Mr. Justice Ouseley concluded was that he decided that what the EAU had done was not systematic.
That's right. Yes, he did
And
say.
we respectfully submit that it was systematic for the reasons that I sought to demonstrate this morning, but particularly by reference to the fact that what the student rights had done was systematic. And the EAU are fixed with that when they encouraged it to be sent to them.
Yes.
And secondly,
Is there any more information about how student rights conducted itself?
We don't have any more information than is in those statements. All we know is that it's a private organisation that were providing the EAU with information, and the EAU encouraged it and asked for them to provide them with more.
Yes.
But you've seen page 418 of the core bundle, the kind of information that they were obtaining was all publicly available information, but they pulled it together to form a profile.
Yes.
Now, my lords, what we respectfully submit is that if this is private information, then this is a case where a directed surveillance it also meets the criteria for a directed surveillance authorization. Now, I should make clear that we don't suggest that actually the EAU would have been able to get a directed surveillance authorization, not least because the Home Office are not authorised to obtain directed surveillance authorisations for this purpose. However, we say that what the EAU did amounted to directed surveillance within the meaning of RIPA.
Does it follow that you say, one, they couldn't have got a directed surveillance authorization, two, this is an incursion of private life, so three, unless and until there's been an assessment of the justification, the state can't collect such information as this?
Well, for the purposes of this definition of extremism, yes.
So the state is not able, until they've done an assessment of the impact on the individual, is not able to collect this information. How on earth would they know what the impact is?
What the state can, if this is private information, and if this is directed surveillance, which is the submission I'm about to develop, then under RIPA, it would be open to the state to do two things. Firstly, to add the Home Office to the schedule of in RIPA, in the RIPA order, to make this a subject which the Home Office would be entitled to obtain a RIPA authorisation. So that would be done by way of an amendment to the order. And secondly, they would need to make an order under Section 28(3), Subsection G of RIPA, which I'm going to take your lordships to in just a moment. So they can carry out this, but they need to do it in a lawful way. That's what this case is about. It's not about whether they can obtain the information. Now, there is a further issue here, which is that we say that the whole definition of extremism is too vague and overbroad. And if we were right about that, then, of course, it wouldn't be lawful even if it was in statute for the state to be able to obtain or to interfere with private life for that purpose. But I don't have to go that far for the purposes of this argument. So, my lords, the reason why this is directed surveillance, it's important to bear in mind that RIPA was introduced in the first place to comply with the Human Rights Act following the decision of the European Court of Human Rights in Halford against the United Kingdom, when it was discovered that there was no mechanism for authorising intercepts on a private, in that case on the police's internal telephone system. And in Halford, the Strasbourg court held that that meant there was no lawful basis for the phone tapping that had happened in Mrs. Halford's case. And RIPA was introduced as a means of providing authorities with to be able to obtain this information in a lawful way. Now, it doesn't require them always to get a RIPA authorisation, because some public authorities have already got powers that are sufficient for the purposes of Article 8. And so when you read in the submissions on Mr. Justice Ouseley's judgment that RIPA is permissive, well, all that means is that the fact that there is no RIPA-directed surveillance authorisation in a case where what amounts to directed surveillance has been carried out does not mean that it's automatically unlawful. You still need to consider whether the source of the power is one that itself complies with Article 8. So, for example, the Police Act 1997 confers certain powers to obtain search warrants, surveillance warrants. The Intelligence Services Act 1994 confers powers on the intelligence services. And in those circumstances, what they do under a warrant which amounts to directed surveillance would not be unlawful just because they didn't get a directed surveillance authorisation. Now, my lords, the reason why this is important is because we say if what happened here amounted to directed surveillance, Parliament has already said that it must be accompanied by safeguards that comply with Article 8.2 that amount to at least the equivalent safeguards that are available under RIPA. So if you reach the conclusion that that this did amount to directed surveillance, then you would need to go no further in order to decide whether there was a breach of Article 8.2, because if you found that the law under which the EAU was operating did not contain the same safeguards as RIPA, that would mean that it was not in accordance with the law. But it also indicates the kind of safeguards that would need to be made in order to comply with 8.2, even if I wasn't right with that proposition, even if I'm not right that you can assume that the safeguards must be equivalent to those in RIPA. You've still got to ask yourself the question, does what was done by the EAU comply with the requirements of being in accordance with the law and necessary in a democratic society? So that's why I just wanted to show you.
Really, so I need to just make sure I understand this, because I'm not familiar with this area of the law. And what I'm understanding you to say is, if Article 8 is engaged, would you then move into Article 8.2 in order to decide whether nonetheless it's safe because there's some purpose of 8.2, so presumably it's security and welfare of others, safety of others.
Yes.
Then, once you've decided that it amounts to directed surveillance within RIPA, in accordance with the law, means that you have to satisfy the requirements of RIPA.
Yes.
That's to understand what you're saying.
Yes.
But then I got slightly lost, because you then said, well, we don't have to worry about whether or not this ever could have been done under RIPA. But now actually you're saying it couldn't have been done under RIPA.
Well,
so I'm sorry, I'm a bit slow here. I'm just trying to make sure I understand what you're saying.
let me put it this way. If this amounts to directed surveillance and it had been done under RIPA, that would be the end of the matter.
Yes.
No doubt about it.
Yes.
Mr. Sanders and I agree that this couldn't be done under RIPA.
We're agreed on that.
We're agreed on it, because the Home Office are not authorised under the RIPA order to carry out surveillance for this purpose, unless it amounts to an immigration purpose. I think that's right, isn't it? Unless it amounts to an immigration purpose. And I'm going to show you, Lordships, why this is in just a moment. So, if it amounts to directed surveillance, they couldn't do it under RIPA. So you then have to ask yourself the question, well, you have to ask yourself the question anyway, because they didn't do it under RIPA, is the law under which they carried out this surveillance, if you accept that it is surveillance, in accordance with the law for the purposes of Article 8.2. So you look at the source of the law, and if the source of the law is sufficient to comply with Article 8.2, so if they did it under the Police Act 1997, for example, or under the Intelligence Services Act, both of which allow for, but not common law powers, my lady. That is my submission. So we say that in putting to one side the fact that there was no RIPA authorisation in place, we say that there are 5 features of the law that was employed that mean that this was not in accordance with the law.
Is there somewhere in your core submissions where I can follow this?
My Lord, we are at the moment dealing with my third submission.
So, but where we've got to now, you're following my analysis. So if this is directed surveillance, unlawful.
Yes.
If it's not directed surveillance, is there any other source of law for this? So we've now moved from RIPA into it's not a RIPA case.
Well, I'm still going to go back and show you the RIPA provisions.
No, but if you're both agreed, that for the reason you've given, the Home Office could not have done this under RIPA, as matters now stand, that's the end of that. Now why do we need to go further on that, so far as RIPA is concerned?
Well, my Lord, because we say it demonstrates that if this is directed surveillance, it demonstrates the level of safeguards.
Yes.
It demonstrates the level of safeguards that Parliament has decided are appropriate for an interference which constitutes directed surveillance under Article 8.2. And the fact that the law under which this was authorised, namely prerogative/common law, does not meet that standard.
But that simply means Parliament set out a specific regime to protect those agents of the state who operate under RIPA. That's not a legal definition of the minimum safeguards. It's merely an analogy.
Well, my Lord, as I said, that is my first submission in relation to under the fact that this was not in accordance with the law. So we say
you
even
say it's RIPA
yes,
because it's directed surveillance.
yes,
Agreed that if it is RIPA, no lawful authority under RIPA. You then go back to A2, and I thought that, and you're saying that it's permitted to be done, this surveillance, under common law prerogative.
yes.
Why then you talk about the Police Act?
Well, I'm sorry. So what RIPA does is it says that if you get a directed surveillance authorisation, it will be lawful. But if you don't get a directed surveillance authorisation, it doesn't mean that it's unlawful.
Understood.
See Section 80.
Right.
What you have to do is you've got to go and look at the source of the power, the source of the authority under which you did act,
Yes.
and ask, does that meet the criteria of Article 8.2?
It said it's common law prerogative.
Right. And I'm now going to set out my 5 reasons why, putting to one side my RIPA point,
Yes.
why this does not meet the standards required by Article 8.2.
Understood.
So the first is that the prerogative or common law power to research, collect, analyse and disclose information is too broad and unfettered. So it doesn't set out the conditions under which the law can be exercised. So it provides that a public authority can collect information, but it doesn't set out the circumstances in which it can do so. So that's the first reason.
Yes.
I'll just list them, my lords, and I'll come back and develop them. The second is that the detailed safeguards required by Article 8.2, so that these are the safeguards rather than the primary conditions in which they can be exercised. The detailed safeguards that are required by Article 8.2 are not set out in a document or documents that has the status of law, because it's set out in an unpublished policy which is not binding on the state. The third is that the purpose for which the power may be exercised, namely to investigate extremism, which includes non-violent extremism, is too vague and is overbroad. The fourth reason is that Dr. Butt was not given adequate notification of the fact that his data was being processed or that he was under surveillance, to enable him to have an effective remedy. fifth point is that in any event, because there was no RIPA authorisation, he was unable to exercise his remedy before the Investigatory Powers Tribunal, which is the only exception that the Strasbourg Court has identified for a situation in which it's not necessary to give a person notification of the fact that they've been the subject of surveillance. So those are the 5 reasons why we say Article 8.2 is not met. So in relation to the first proposition, can I take your lordships to the case of Zakharov, which is at volume 4, tab 92. This is, Zakharov is the most recent Grand Chamber decision on surveillance measures.
So I didn't get that reference.
Zakharov, my lord, Zakharov. It may be possible to...
Where would we find it? I'm sorry, I didn't take down the reference.
Zakharov is volume 4, tab 89. Sorry, no, it's
92.
tab 92. Paragraph 227, the court sets out the general principles in relation to whether a measure that interferes with Article 8 rights is in accordance with the law. This is an interception of communications case. We're no longer on the question of whether Article 8 is engaged, so this is on the second point. Paragraph 227 on page 3553, does your lordship and your ladyship have that? So the court reiterates any interference can only be justified under Article 8.2 if it's in accordance with the law, pursues one or more of the legitimate aims of paragraph 2 of Article 8 and is necessary in a democratic society in order to achieve any such aim. I should point out, we just jump forward to paragraph 236. The court in this case, and what we respectfully submit this court should do, considered both the in accordance with the law and the necessary in a democratic society provisions together. And you'll see at paragraph 236 why that was. In cases where the legislation permitting secret surveillance is contested before the court, the lawfulness of the interference is closely related to the question whether the necessity test has been complied with, and it is therefore appropriate for the court to address jointly the in accordance with the law and necessity requirements. So, if you go back to...
What does that mean?
Well, it means, my lords, that you need to look, for example, at the question, are there adequate safeguards to protect Article 8? You would also need to look at the question, are the safeguards proportionate to the kinds of interference that are being authorised?
So if the interference is minimal, and the safeguards too may be low?
Yes. Paragraph 229, paragraph 228, going back, my lords, the court notes from its well-established case law that the wording in accordance with the law requires the impugned measure both to have some basis in domestic law, which is not an issue, and to be compatible with the rule of law, which is expressly mentioned in the preamble to the Convention and inherent in the object and purpose of Article 8. The law must thus meet quality requirements. It must be accessible to the person concerned and foreseeable as to its effects. The court has held on several occasions that the reference to foreseeability in the context of interception of communications cannot be the same as in many other fields. Foreseeability in the special context of secret measures of surveillance, such as the interception of communications, cannot mean that an individual should be able to foresee when the authorities are likely to intercept his communications so that he can adapt his conduct accordingly. However, especially where a power vested in the executive is exercised in secret, the risks of arbitrariness are evident. It is therefore essential to have clear, detailed rules on interception of telephone conversations, especially as the technology available for use is continually becoming more sophisticated. The domestic law must be sufficiently clear to give citizens an adequate indication as to the circumstances in which and the conditions on which public authorities are empowered to resort to any such measures. So, my Lord's just pausing there. We respectfully submit that that means, among other things, that the power under which a public authority is exercising its powers, the power under which it is carrying out any interference, must set out not only the fact that it's a general power to obtain information, for example, but for what purpose and in what circumstances that power may be exercised. So just for example, in the cat case, where the power that was being exercised was the common law power of gathering and processing information, the code of practice under which the police were operating set out the purposes for which information could be processed as police purposes, and they defined police purposes very closely. So it didn't need to be set out necessarily in the common law, but you need to find somewhere some legal instrument which has the status and quality of law that sets out the circumstances in which the EAU can carry out an investigation into extremist behaviour. So that could be, and in fact it should be, in a piece of primary legislation. But if it's not in primary legislation, if there were, for example, a binding code of practice setting out exactly the circumstances in which the EAU could act, then that would meet this particular requirement. If you just carry on with paragraph 230, moreover, since the implementation...
Why do you say it has to be in a statute? Why can't it be common law?
Well, it can be in common law if the conditions under which it may be exercised are set out in some instrument that has
So set out in some instrument.
So some instrument that has the status of law.
Well,
So
why do you say that?
well, my lord, because for reasons I'm going to develop, the law.
The law has to be clear.
Yes, but it can't be set out, for example, in an unpublished policy. So
policies and law.
So the policy which sets out the powers of the Extremism Analysis Unit, they are the policies that I referred you to earlier. They were all unpublished policies that were in fact in draft form during the course of what was being done in Mr. Butt's case. Those policies do set out the circumstances in which the EAU operates, but they do not have the status of law for the purposes of Article 8.2, because they're not accessible, because they're not published, because they are not binding on the executive, because the state can change them. Now, it's accepted, has been accepted, that the law does not necessarily need to always be set out in a statute. That's the Silver in the United Kingdom case, and in CAT the Supreme Court accepted, for example, that the common law power was adequate there. But the point that I seek to make in that context is that there was a code of practice, a published code of practice, which set out the circumstances in which information could be processed, and they were limited to police purposes. And those police purposes were closely defined. What we have here is, as I've said, a power at common law to carry out, well, to investigate, to share information, to process, but it does not set out the circumstances in which that may be done.
Can you explain to me how I'm sure you're going to come on to it, but when the judge was considering this part of the case, he put emphasis on the Data Protection Act.
Yes.
And are you going to deal with
I am, my lady.
this
So
analysis?
the key reason why the Data Protection Act doesn't satisfy this aspect our case is because Mr. Butt could not have exercised his rights under the Data Protection Act because he did not know of the fact that his data was being processed. So the Data Protection Act works upon a principle that an individual is given notice of the fact that their data is being processed. And in CAT, for example, the Supreme Court held that the Data Protection Act was a suitable remedy.
What the judge said about paragraph 247, he didn't accept that the law required the claimant to be notified on any of the 3 occasions when his data was processed that this was happening.
We've respectfully submitted he was wrong to reach
Yes, I
that
follow
conclusion.
that, but I just want to know how this fits in with the submission you're making at the moment, because what the judge said was, well, it's not really practical. There were 3 occasions here, and it wouldn't have been practical to inform a data subject every time there's an element of research. In any event, by October he did know, and then he could ask.
Yes. Well, my lady, I understand the point that because this was the conclusion that was reached by the Supreme Court in CAT, is that the availability of the Data Protection Act in circumstances where Mr. Cat knew that his information was being processed meant that the interference was one that was in accordance with the law. Because Mr. Cat knew the police were interfering with his private life.
Well, he just knew that photographs were being taken to the demonstrations.
Exactly.
That's what he knew.
It was all done.
How does your submission on this square with the passage you read to us from Zakharov, for example, at page 229? Foreseeability in the context of secret measures of surveillance, which you say this is, such as interception of communications,
yes,
cannot mean an individual is able to foresee when they're likely to intercept.
Well, I'm going to take you on to some other passages in Zakharov, because what Zakharov basically says is this, that you can't have the same degree of foreseeability so that a person can foresee and adjust his behaviour accordingly, because that would of course defeat the very object of But what it does mean is that the need for laws that set out clearly the circumstances in which a power can be exercised is a heightened one in those circumstances. It's particularly important in those cases that the law is set out with particularity. So, my lords, in a series of cases, the Strasbourg Court has found English decisions to carry out interception under UK law did not comply with this obligation. So the classics, and I'll take you to a couple of them, but the Halford case is one, the Malone case is another, the Copland case is another. Just bear with me, my lords. And PG in the United Kingdom was another. So if I could take you to that decision, which is at volume 6, tab 115. So volume 6 of the authorities.
Pause here. If we can take up 229 again, the sentence in this that you're relying on is the last one.
Yes.
Domestic law must be sufficiently good for citizens an adequate indication as to the circumstances in which and the conditions in which public authorities are entitled to resort to any such measures. Just pausing there. The requirement isn't that they know that they should be able to intervene, but that the law itself, as to the circumstances in which the power can be exercised, must be clear.
Yes, exactly.
So I'm just trying to think this through with the DPA. So what the DPA tells the citizen is that in handling data, various conditions have to be, I think it's the 7 conditions have to be satisfied. So what it says is, provided that you comply with these data conditions, you can do whatever you want with the data, subject to people's rights to do various things, to block it and for whatever reason it may be. Now, so I'm going back on my lady's point just to try and drive this, as it were, to ground. why does the Data Protection Act not tell the citizen in what circumstances data which is lawfully acquired can be retained and handled? Why is that not sufficient?
Well, my lords, for this reason, that the lawfulness of the gathering of information and the processing of information under the Data Protection Act is dependent upon a number of safeguards. Those safeguards are meaningless if an individual does not have adequate notice that their data is being processed, and they cannot exercise. So if they cannot exercise their remedies, it means that they can't. So in terms of the first question, is this a law under which the state has a power to process information? I accept that it is. But that's not in fact what.
But I'm just wondering if that last sentence goes that far, because this whole paragraph, as has been pointed out, is about secret measures of surveillance. So you can't notify people if you want to carry out secret surveillance. But in those circumstances, although somebody may not know that they're actually under surveillance, indeed it would be contrary to the effectiveness of surveillance so to inform them, it's okay, it's sufficient if the domestic law gives the indication as to the circumstances in which and the conditions in which, generally speaking, under the law, public authorities are empowered to resort to such measures.
Yes.
So it can't be to enable, it can't be that last sentence to enable somebody to exercise their right, because ex hypothesi, they're not going to know that there's going to be surveillance. So what you seem to be saying, though, is transposing it to our case and saying, well, the trouble in the present case is he wasn't notified that we were doing this, but the whole paragraph 229 proceeds on the basis that the person wouldn't be notified.
Yes. So I'm going to have to come at a separate point to the notification requirements, which are in Zakharov. At the moment, I'm dealing with the first point, which is what is the power under which the EAU was acting when it obtained the information and when it processed it. Now, certainly part of that was the Data Protection Act, but the process of going out and gathering information in the first place as an investigative body, that was a power that Mr. Sanders invokes, for which Mr. Sanders invokes the common law and the prerogative. And what I'm submitting at the moment is that power is not set out anywhere in law with sufficient particularity for a person who may be suspected of being an extremist to know that it would be exercised for the purposes of an investigation into whether he is an extremist. And that the Article 8.2 requires that the law, if a power is to be exercised for that purpose, that the law set out in an instrument that has the quality of law the fact that it can be exercised for that purpose. And it's not enough to invoke a generalised, unfettered power like that which exists at common law or under the prerogative.
Well, that's another way of saying it. No common law powers can exist.
Well, my lord,
unless they're written down, in which case they're no longer common law powers.
Can I take you to the PG in the United Kingdom case to make good this proposition, my lords? It's at volume 6 of the authorities bundles. It's tab 115.
Bundle 6.
Yes, it's bundle 6. That was the bundle that was put on your lordship's bench this morning. Volume 6, tab 115. And if we pick it up at paragraph 35,
Yes.
I'd ask you first to read paragraphs 35 to 38,
Yes, we'll do that.
and then to read paragraphs 62 and 63. My lord, you see when you get to paragraph 62 and 63 that in relation to the covert listening device in the police station, it was being that the government sought to rely upon the general powers of the police to store and gather evidence, which is the same power that's being relied on here.
Mr. Bone, I'm sorry, I know this whole field is difficult because every time you look at another example, you have to then say, can you construe a principle from a different set of circumstances?
Well, my lord, what we're dealing with here is...
This case was concerned with intrusive surveillance into people's homes.
Well, actually, this particular bit was to do with surveillance in a police station. This part of this part of PG in the United Kingdom, where a covert listening device was used in the police station. There were different aspects that were challenged. So, paragraphs 35 to 38 are dealing with covert listening
On
devices.
the 4th of March, the Chief Constable gave authorisation, and that day a listening device was installed in a sofa in the flat.
Yes, so 35 to 38 was dealing with the covert listening device in the home, and then the covert listening device in the police station is being dealt with at paragraph 62 to 63.
Yes.
I beg your pardon.
Well, the
point, my lord, my lady, is this. If you accept that this is an interference with Article 8, if you accept that this is a form of surveillance, and indeed if you accept that it meets the requirements of directed surveillance under RIPA, then the state needs to have authority which set out explicitly the circumstances in which it is carrying out those investigations.
Why isn't it sufficient? There may be no case covering the point I'm about to make, but why is it not sufficient that even though there's a non-statutory common law right to collect the material, why is it not sufficient? There is a statute which tells you what you can't do with it.
Well,
if it prohibits you from doing X, Y, or Z with it, why should that not be sufficient?
well, it's got to authorise you to be able to obtain it in the first place.
Well, that's the question. I mean, you can't. Let's assume that under Data Protection Act, it can't be used for certain purposes without your consent, or without your knowledge, or whatever it may be.
Yes.
Why isn't that in reality sufficient to amount to in accordance with the law? Because what you're concerned about isn't the collection. What Dr. Butt here is worried about is not actually the collection of material. He's worried about its use. He doesn't want it to be used in particular ways.
I mean, I'm dealing with a submission that's been made that the powers of the police, the powers of the EAU are the general powers that all public authorities have to obtain and collect information and to use that information. And I'm taking you to PG in the United Kingdom for that purpose.
I understand that.
whether the Data Protection Act authorises the conduct of invasive surveillance, sorry, not invasive, of covert surveillance. There's nothing in the Data Protection Act which says that there is authorisation to carry out what is defined in RIPA as directed surveillance. The only place where you will find authorisation to do that is in RIPA or in under other specific legislative powers that authorise the carrying out of covert surveillance. So if you're with me that this is covert surveillance, then the Data Protection Act does not provide express statutory authority for that purpose. That is the answer to my Lord's question. And what these cases demonstrate is that when the state wants to carry out something in secret, the courts will not make the state advertise that fact so as to defeat the very purpose that it seeks to achieve, but it will insist on very clear laws setting out the circumstances in which a power can be exercised. Now, I was going to take you to RIPA, and I'll give you an example, if I may, by taking you to RIPA. If we look at section 28 of RIPA, which your lordships will find in the first volume, start with section 26, my lords, at volume 1, tab 14, page 283. My lords will see section 26.2, subject to subsection 6, surveillance is directed for the purposes of this part if it is covert but not intrusive and is undertaken for the purposes of a specific investigation or a specific operation, and in such manner as is likely to result in the obtaining of private information about a person, whether or not one specifically identified for the purposes of the investigation or operation, and otherwise than by way of an immediate response. And then if you turn to paragraph 9, explains what is covert surveillance. For the purposes of this section, surveillance is covert if and only if it is carried out in a manner that is calculated to ensure that persons or subjected to the surveillance are unaware that it is or may be taking place. And we respectfully submit that that test is met. And then subparagraph 10, in this section, private information in relation to a person includes any information related to his private or family life. So, my lords, if it is directed surveillance, then you turn to paragraph 28.
So what was the one you were reading out before 10?
Section 26, my lord.
No, I've got section 26, I've got section 26.1 and 10. What was the other section?
Subsection 9.
9.
That's what describes, that's what tells you what is surveillance. Sorry, what is, when surveillance is covert. I'm going to show you in a moment what surveillance is. In fact, perhaps we just do that and then go back to section 28. So if you go to paragraph section 48 on page 319, subject to subsection 3, this is subsection 2 of 48. In this part, surveillance includes A, monitoring, observing or listening to persons, their movements, their conversations or their other activities or communications, recording anything monitored, observed or listened to in the course of surveillance, and surveillance by or with the assistance of a surveillance device. Well, we obviously don't rely on little c, but we rely on A and B for this being surveillance. And my lords, it's covert if, and I just showed you section 26 subsection 9, it's calculated, it's conducted in the manner that's calculated to ensure that persons who are subject to it are unaware that it is or may be taking place, and it is in such a manner as is likely to result in the obtaining of private information. Now, if your lordships are with me on that question, then section 28 provides that there needs to be an authorisation. subsection 2 of section 28, a person shall not grant an authorisation for the carrying out of directed surveillance unless he believes A, that the authorisation is necessary on grounds falling within subsection 3, and B, that the authorised surveillance is proportionate to what is sought to be achieved by carrying it out. And then subsection 3 sets out the grounds on which it can be granted. It's in the interest of national security, preventing or detecting crime, interest of economic well-being, public safety, protecting health, tax or other levy, and then little g for any purpose not falling within paragraphs 8 to f, which is specified for the purposes of this subsection by an order made by the Secretary of State. And subsection 5 provides that the Secretary of State shall only make an order on subsection 3g if a draft has been laid before Parliament and approved by way of positive resolution. Now, my lords, what my submission is that if what is being carried out is directed surveillance, then the law needs to set out the fact that directed surveillance can be carried out for this purpose. Now, we respectfully submit that the carrying out of surveillance for the purposes of deciding whether somebody is an extremist doesn't fall within any of those categories. But even if it did, it would need to set out the fact that this is a purpose for which the power can be exercised. Sorry. It must set out that the power of surveillance can be carried out for the purposes of investigating whether somebody is an extremist.
Does it follow that you would say that the activities of the security service, looking at a range of people to see whether they are or are not extremists, means that since that purpose isn't explicitly spelled out in the statute, any genuine covert surveillance without any argument about it would be unlawful?
My lords, I've no doubt that any investigation into whether somebody is a violent extremist, and I stress the word violent, will be something that falls within both national security and the prevention of crime.
Okay. So we're back to the definition of
We're back to the
which I
definition.
understand.
And that's why, my lords, it's important, because if I'm right that this is a form of surveillance, and I accept that that is a matter that you need to find for me on, that there's an interference with private life and it amounts to monitoring, which is covert, which constitutes surveillance, for which a directed surveillance authorisation would ordinarily be appropriate, then at the very least there would need to be an order under subsection G of section 28 to authorise a directed surveillance for the purposes of investigating non-violent extremism, because non-violent extremism would not fall within
What
any of
if
the
you're
others.
wrong? What if it isn't?
I beg your pardon.
What if it isn't directed surveillance?
If it is an interference with private life but doesn't amount to directed surveillance, it still is an interference which requires to be in accordance with the law. And my lords, my lady, the significant thing about this is that as soon as the state is carrying out an investigation which is sufficiently sensitive that the fact that the investigation cannot be disclosed to the individual, then I would respectfully submit those are the circumstances that the court is talking about in Zakharov, and that is when the heightened need for the law to set out the circumstances in which such an investigation can be carried out arise.
And you say that the EPA isn't sufficient for this purpose?
Well, my lady, it's not sufficient for this purpose because it doesn't cover what it is that is being done here.
It doesn't, well, it governs the, does it not govern, I'm trying to remember back to the DPA, but I think processing does include collection of data, does it?
It does, ma'am.
It covers collection and handling.
It does.
So if it covers the collection of data and it tells you how you, what are the constraints on your collecting it? I go back to my previous question. What is wrong? Why is it not in accordance with the law if there's a general law that you can collect, but it's subject to all the restraints and restrictions specified in the statute?
Yes, but those restrictions and restraints include a number of safeguards, my lord, and those safeguards need to be exercisable. So even if you were against me on my first reason, I gave you 5 reasons why the law does not meet the requirements of Article 8.2. The first one is it's got to set out clearly the circumstances in which an interference may be carried out. The second is that the safeguards must be set out in a legislative or an instrument that has the quality of law. Well, my lord would no doubt point out that the DPA does have a number of safeguards, which is why that we then push the problem further down my list of criticisms, if I may put it that way, of law, which is that the safeguards that are available under the Data Protection Act are not exercisable by somebody who is unable to know that they are the subject of an investigation.
I think we've covered that ground already, haven't we?
Yes. Well, my lady, what I need to do is I do need to show you the case law which supports that proposition. That is to say that there's a need for adequate notification. I dealt now with there needs to be a law which sets out the circumstances in which you can do this. And even then, my lords, my lady, there's nothing in the Data Protection Act that says that that there can be covert investigation amounting to on the grounds of extremism. It's simply not what the Data Protection Act is designed for. But I've made my submission in relation to that. I've made my submission in relation to the safeguards needing to be set out in a document that has the status of law. If the only safeguards are those that are set out in the policies, then it doesn't meet those requirements because those policies are unpublished and don't have the status of law. I've made the submission that the purpose for which the power may be exercised is overbroad, but that's in fact a submission I'm going to come back to with more particularity in relation to the second challenge to the prevent duty guidance. So I'm going to, if I may, keep that in reserve until I get to that point in my submissions. But the fourth
we should
criticism,
note here that falls within your Article 8.2 points. We're going to deal with it later on,
yes,
but it is part of your Article 8.2.
it's part of my Article 8.
Extremism is too vague and general.
It's too vague and generalised and overbroad. But the fourth criticism was that the appellant has not been given any notification of the fact that his data was being processed in order to enable him to have an effective remedy. Now, my lords, my lady, there are 2 sources of law for this proposition. One is the secret surveillance case law, and the other is data protection legislation. So, if this is secret surveillance, then I'm going to develop this submission, that at the very least, there must be either notification once that would no longer prejudice the conduct of the investigation, or a remedy that can be exercised without the need to demonstrate that there's been any interference, any.
Right. I need to understand the structure of this. If we're with you that it's surveillance,
Yes.
we'll have to hear what Mr. Sanders says. But I assume you say it automatically follows it's directed, and I assume directed is not.
It's definitely not intrusive. It's directed.
It's directed. It's
Yes.
directed. So if it is surveillance, it's directed surveillance, and you're agreed that RIPA doesn't apply.
Yes, not perhaps for the same reasons.
It doesn't matter.
But we're agreed that
So
it wasn't available to them.
So you get home on that, whatever happens. Well, hear what Mr. Sanders says, but at the moment you say
Well, he was saying
it
that
would
that
require
doesn't
an
make it
order. It would
unlawful.
require an order. There was no order. There couldn't be an order. Finished. End of argument. Now, if we're against you on the surveillance point, it's not surveillance. So we're against you on that. But you succeed in persuading us Article 8.1 is engaged.
Yes.
what then is left under your Article 8? You've got under Article 8.2 that extremism is too vague. You've still got that point.
Yes.
But what else have you got on the position in accordance with law? Because
Well, you still need, in order to process private information, whether you're doing so as a part of secret surveillance or not, you still need to meet the in accordance with the law requirements.
Right,
They're set out.
it's in accordance with the law, but it's not surveillance.
Yes, so if you look at, probably the best and easiest way to take you to this is NN in the United Kingdom.
Right.
And that is Volume 3, Tab 80, page 3017. And it's paragraph 193 to 195.
So this point that we're at is it's not surveillance. Article 8.1 is engaged. You're not going to give a point about necessity. I mean, you're not going to argue it's not necessary.
No, for these purposes, we're just going to deal with the inequality.
So the only thing that's left now is the issue whether or not you satisfy the requirement of 8.2, or the government says the requirement of 8.2, in accordance with the law.
Yes.
Right, okay.
Now,
And you say this
I accept for these purposes, I'll just preface my remarks here. If this is just processing of private information and is not directed surveillance, then the Data Protection Act would be an adequate source of law for the purposes of that processing. So my first submission would necessarily fall away in those circumstances, and I'm left with the fact that there's no notification, which is my complaint number 4, if you like.
Right, well, that is the basis on which we're proceeding. We're presuming it's not surveillance.
I understand.
It's not surveillance. And do I understand you to say that you accept that if it's not surveillance?
There is a basis in law.
There is a basis in that's the DPA.
But then we need to look at the question of the safeguards, and that is part of the in accordance with the law requirement. And so these paragraphs are also relevant to, if you like, my second submission, which is that there needs to be adequate and effective safeguards, and is also relevant to my fourth submission that there was no notification, which is the key safeguard.
Which tab again?
My lady, it's tab 80, and it's page 3060, paragraph 193. Now, my lady, this was not a covert listening case. This was a case about the power of the state to retain and disclose previous convictions. Cautions, I beg your pardon, my lady. But it's the principles that are relevant. And again, if I just ask my lord, my lady to read paragraphs 193 to 195, I'm sure they're very familiar to you. Read those paragraphs, but perhaps you turn to paragraph 202.
And then
202. just stop at the 6th line of 202 and then pick up paragraph 203, the first 6 lines. Paragraph 206 and 207. It is correct that in the CAT case, the Supreme Court held that the existence of a power to collect information and store it and share it was derived from common law, and that was sufficient for those purposes. But I've made the point that in CAT there was a written, a published statutory code of practice which defined the purposes for which information could be gathered and stored and shared. And that is a key distinction with the present case, because if there is a power to collect, share and store information under common law or the prerogative, it is not accompanied by any equivalent document to the Management of Police Information Code of Practice, which was what was in play in CAT. The second point to make is that in CAT, the Supreme Court distinguished the case that I've just shown you on the basis that it was a case involving mandatory disclosure of caution data rather than discretionary disclosure. But the key point is that in CAT, the Data Protection Act provided an adequate remedy because Mr. Cat knew that he was the subject of an investigation. So, my lords, two points to make. And if I can perhaps just modify the submission that I made. We're looking at the moment, in this scenario, that your lordships are with me that there is private information in play. You're against me that it is directed surveillance.
That is surveillance.
That it is surveillance. So that it is merely processing of data. We respectfully submit that it's not, the DPA does not give the EAU the power to do that. The EAU governs the circumstances and the safeguards. Sorry, the DPA governs the circumstances in which it is lawful to process information. It does not confer the power to collect, store and share it. That power is found in the common law / prerogative. So for the purposes of this submission, my lord, this is on the premise that you're against me that it's surveillance.
Yes.
there still needs to be a source of power which is sufficiently clear and accessible to explain that the state can obtain information about whether somebody is or is not an extremist and form judgments on that and to share that with other individuals, with other public authorities. So the DPA does not provide the source of the power. It provides the safeguards. And that's why we get to my...
What you haven't got in MN, am I wrong about this, but it's interesting, what you haven't got in MN, which you had in the previous case, which was concerned with secrecy. Isn't there an express statement here that it has to be in statute?
Yes, so there is a curious. I'm not going to develop a submission before your lordships that it has to be in a statute. It could be in a statutory instrument. It could even be that if there were a statutory code of practice, for example, that set out the circumstances in which counter-extremism why non-violent extremism could be investigated, that might be sufficient.
Public policy isn't.
But an unpublished policy is not.
Well, you went to unpublished. You did refer us to a document which should explain the setting up of the EAU and why it was set up.
Well, I think the only document that sets out, makes any reference to the EAU is the 2015 counter-extremism policy, which just says that we will use the extremism analysis unit. It doesn't set out what the policy's got to set out. It's got to set out the detailed conditions in which it can be exercised and the safeguards that are available. And I accept that the policies that I've referred you to, I haven't taken you to them, but my lords, it's on your list, I'm afraid, of essential reading that will need to be looked at in detail. Those policies, even if they would be sufficient for the purposes of the law, if they were published, simply cannot be taken into account if they're not published.
Well, the judge didn't take them into account,
He did.
he?
That's right, my lady.
But he never got that far because he said there was no. I don't think he ever got that far, did he?
Well, my lord, he said
Maybe
he just he didn't take them into consideration. As far as the judge was concerned, Mr. Butt could reasonably have anticipated, was the word he used, could reasonably have anticipated that he would be the subject of an investigation by the EAU. That had he done so, he would have been able to exercise his rights under the Data Protection Act, and that those rights were adequate for the purposes of Article 8.2. To which I respectfully submit Mr. Butt could not reasonably have expected to...
Well, hang on, well, that's a question of fact.
Well, but it's, my lord... Let me come back to that. What I respectfully submit in relation to the question of compliance with Article 8.2 is that, firstly, the Data Protection Act doesn't provide the power. The power comes
You've
from
got that one.
common law. And while it does contain safeguards, and I accept that it would be capable of amounting to the kind of detailed exposition of safeguards, it doesn't and cannot, in circumstances where the information is designed to be obtained in a way that a person cannot know that it is being obtained or processed, because the DPA proceeds upon a premise that individuals have adequate notice of the fact that their data is being processed. And I'm about to develop those submissions now. That's my point, my criticism of what is wrong with the legal framework. Now, I'll start, if I may, on the premise that this was surveillance, and I'll look at the surveillance cases.
No, I don't see the point of that. I mean, if it's surveillance, the moment you can come back on reply if you want. The moment, if it's surveillance, it's directed surveillance, and they're out on that one. It was unlawful.
Well, my lord,
So I just don't see the point of going back.
I understand Mr. Sanders' submission to be this: that all that RIPA does is it provides a framework within which public authorities can get an authorisation to carry out surveillance, directed surveillance. But if they don't do so, it doesn't mean that what they do is necessarily unlawful.
The judge accepted that argument.
And it will depend upon and I accept that argument. It depends upon whether the source of law under which they are acting itself meets the requirements of Article 8. So if they're operating, as I've said, under the Police Act 1997 or the Investigatory Powers Act 1994, that was precisely the sort of situation which it was envisaged in RIPA. It would not be necessary to give a directed surveillance authorisation because there is an existing power. So I still need to show that the use of the powers that were used, common law / prerogative, were adequate and accessible and foreseeable, or were not adequate, accessible and foreseeable for the purposes of Article 8.2. But my submission works in, firstly, that only a RIPA authorisation can be in accordance with the law if it amounts to directed surveillance. But even if I'm wrong about that, or if it doesn't amount to directed surveillance, it's still not in accordance with the law because the law is not sufficiently clear and precise, setting out the circumstances in which it can be used. No, sorry, I'm explaining why.
Until now, I hadn't appreciated that you were accepting that even if this was directed surveillance within RIPA, but RIPA wasn't satisfied, nonetheless it could still have been lawful.
No, I don't accept that it would have been lawful. I accept that it doesn't mean that in and of itself that it's unlawful.
Yeah,
I still need to show that it's not in accordance with the law. But my first submission on that
it's 4 o'clock now, I think, and I think to some extent we're going round in circles.
No, well, I understand. My lord, this is not the easiest of material to get through, and I hope your lordships will indulge me to a certain extent here, because these are not simple, straightforward concepts.
Well, we've got the broad proposition that you've given to us, and you've given some of the cases. You can probably look at the rest of them, which is you were saying whether it's surveillance or it's not surveillance, it has to be in accordance with the law, and the law has to specify the circumstances in which it can be exercised with sufficient safeguards that are accessible. And
Yes.
you've got that point.
Yes. So the next question is well, if you're against me in terms of the existence of the law that does set out clear, detailed conditions in which it can be exercised, then you're against me as to the existence of safeguards, because your lordships consider that the DPA is a sufficient safeguard. Then my next proposition, beyond the overbroad one, is that absence of notification means that in and of itself means the law is not doesn't comply with Article 8.2.
Absence of a requirement of notification or
Absence of a requirement of notification. And if you find that there is a requirement of notification, a failure to provide notification, because we say, and I've always said, that under the Data Protection Act, there is a duty to notify. And such a duty could only be obviated if there was some clear statutory power authorising and providing, or authorising what was otherwise secret, and providing an alternative remedy that's specifically tailored for that situation. That is precisely what's been done under RIPA. So the situation under RIPA is that you've got the right to apply to the IPT, and you've got that right to apply to the IPT. You don't have to show that you've been the subject of surveillance. Anybody can apply to the IPT at any time to say, well, am I the subject of an order authorising my surveillance? Now, I wanted to show you, lordships, the two sources we say for this requirement of notification. It's very important because, of course, Mr. Justice Ouseley was against me on this point, and he found that there was no duty to notify, and that Mr. Buck could reasonably have anticipated that he would be the subject of an investigation. My lords, the case I want to take you to is to take you back to Zakharov, which you'll find we were at volume 4, tab 92. Just pause you now, my lords. Do your lordships intend to sit until 4:30?
It's been quite a long day. We'll stop at 4:15.
4:15, my lords. I hope to finish the first challenge, the data protection EAU challenge, by then. So, my lords, if we pick up the Zakharov case at paragraph 287.
Is it volume 4?
Yes, it's volume
Volume
4,
92.
tab 92. Paragraphs 233 to 234 are also relevant, but I won't ask you to read them now. But if you could read 287 to 288, please.
287.
287 to 288. And in fact, 289 is relevant, my lords. And then 298. With the conclusion at 300. And then, my lords, the Watson case, because precisely the same point has been considered by the Court of Justice of the European Union, I accept in a different context, but this is what remedies are necessary in order to comply with Article 7 of and 8 of the Charter of Fundamental Rights of a person who has had their personal data extracted. And if I could ask you to turn to volume 6, tab 121. Paragraph 121. It's page 5231 of the.
I'm sorry, Mr. Bowden, can you repeat the paragraph again, please?
121. I accept that that the Strasbourg Court has not gone quite so far as the Court of Justice of the European Union has, because the Court of Justice of the European Union has made it a hard rule that there must always be notification. What assumes that notification is no longer liable to jeopardise the investigations being undertaken by those authorities. The Grand Chamber in Zakharov accepted that there was an exception to that if you had a remedy like that under the IPT. That was the paragraph I took your lordships to earlier. Your lordships don't need to resolve whether that creates a difference of approach for our purposes, because Mr. Butt neither was notified, nor did he have the IPT available to him as a remedy. But then what if, my lords, and what's important about this is that these are cases where it's accepted the purpose of the investigation, the processing of data, would be defeated if there were notification. But the courts have concluded that there must be notification at some point once it's no longer liable to jeopardise the investigation. Now, my lords, if it's just a straight straight data protection issue, if it's not secret surveillance, then there must be notification when the processing takes place. Not only for the purposes of the Data Protection Act, but also for the purposes of Article 8. And for that proposition, my lords, and I think this is going to be the last case that I need to take you to this evening, the Supreme Court decision in the Christian Institute against the Lord Advocate, which is at volume 5, tab 106. Sorry, I beg your pardon. It's volume 2, tab 33. And it's paragraphs 85 and 86. Just to introduce this case devolved legislation in relation to the...
So which volume? 2?
Volume 2.
It can't be 23, it starts at tab 30.
33.
So it's volume 2, tab 33.
30, I thought you said 20.
I beg your pardon, my lord.
30, yes. Yes.
But it's paragraphs 84 and 85. I won't trouble your lordships with any more detail about the background, other than to say that under the terms of the legislation, it was implicit that private information about children would be shared between local authorities, albeit for a proper purpose, without the child or their parent being notified. And if I could just ask your lordships and your ladyship to read paragraphs 84 and 85. Now, my lords, I submitted that this is an obligation that arises under the Data Protection Act. Can I perhaps proceed in this way? If I were to cut and paste the 5 reasons why the law is incompatible with Article 8.2 into a note with the references in support of that, I won't need to trouble your lordships with this point
That would be very helpful.
tomorrow.
That would be very helpful, thank
And
you.
I can turn straight to...
Now, how long are you going to be tomorrow?
Well, my lord, I had said initially that I would be an hour tomorrow. I think that might be little bit. I'll be an hour. That's what I said. That's what
But
I
if
told
you can
Mr.
reduce as
Summers.
much as you want to put into writing, to which we can just read through it and we can look at it at training with the references, that will be even better.
Well, I'll do that, my lord.
Yes, we can
I'll
look at the
certainly think
references
of
at
that.
our own time when we're doing the judgment, but you can tell us orally what the principal submission is on each case. Thank you very much.